Me is Felicia O'Connor, and we're from the law firm of Foley and Lardner. And we're glad that you attended today's presentation, which is on preventing whistleblower claims in the automotive industry. Today's program is going to run for 1 hour, and we're going to apply for 1 general CLE credit. So anyone wishing to receive credit for this program today has to enter the code that'll be announced during the polling question during the presentation, and a box to enter that code will appear on your screen for about 30 seconds. If you're from New York, New Jersey, or Kansas and you're applying for CLE credit, you have to fill out an additional attorney affirmation form and write down the course code. The attorney affirmation form and today's slides can be obtained in the resource list widget at the bottom of your screen. If you're a New York attorney, those of you with less than 2 years of experience unfortunately will not be eligible for CLE today. Completed attorney affirmation forms can be mailed to Christina Wade, and her email is cwade@foley.com. And any questions that can be submitted during the web conference can be entered in the Q&A widget, which is open on the left side of your screen. So, and of course, Felicia and I will answer questions as at the end of the presentation as time permits. So let me briefly introduce myself. My name is Jeff Kopp again, and and with me is Felicia O'Connor. We're in the Labor and Employment Group here at Foley, and we're housed in the Detroit office. And so I think that makes us a little bit unique to be able to talk about automotive issues, particularly because of our close proximity to what we would like to still believe is the center of the automotive world here in Detroit. Today, I'm going to jump right into the slides. I think that whistleblower claims are very significant. It's an area of the law that's on the rise. And our goal here today is to talk about these whistleblower claims and some strategies for you to implement and think about in dealing with whistleblower claims in this industry. And let me just say at the outset, our goal is not to make you necessarily an expert in the various statutes that we're going to address, because there are a number of different whistleblower type statutes that we'll mention during the presentation. But the what our goal is to leave you with is real practical advice and thoughts about how to deal with terminations and what are the risks associated with adverse actions that could lead to whistleblower claims. So I think the takeaway at the end of the presentation hopefully will be that you have a very good introduction to various whistleblower concepts and takeaway strategies for how to deal with this to minimize your risk as companies that have employees that could potentially be asserting claims under these various statutes. So as you see on the slide here, OSHA reports that there's been a 58% increase in whistleblower claims over this period from 2005 to 2014. They're not alone in that increase. The retaliation claims in general are also on the rise, and the EEOC reports a 70% increase since 2005. The median jury awards for retaliation are the highest of all employment claims, over $200,000 on average per claim. With the increased number of retaliation claims and this high value dollar, it's something that should be obviously as important to you on the management side. The retaliation is interesting because it's very factual. So unlike perhaps some of the straight-up discrimination claims that you might see, a race or an age discrimination claim, where summary judgment and getting a case dismissed before trial is a good potential outcome. With retaliation cases, it's a lot harder to get that case dismissed without necessarily going to a trial. And once you go to a trial, it increases the amount of expenses and costs that are associated with the case, and it drives the settlement value of the case up. And I think that's what accounts for this high settlement value. This is a recent example of a whistleblower claim that was asserted against Playboy. The plaintiff, a former employee of Playboy, claimed that she was discharged in violation of Sarbanes Oxley, which is one of the statutes we'll talk about today, for after refusing her supervisor, the CFO's, demands to set aside $1 million for executive bonuses that she knew had not been approved by the board of directors. She asserted a claim under the whistleblower protection component of Sarbanes, and the jury awarded her $6 million as a result. So, some of these claims, they obviously can get pretty expensive. I think there's more. There's another whole component to this. I think we'll talk about it later as well. But just becoming involved in any of these kinds of whistleblower actions, there's a non-monetary component to it that you definitely have to think about as well, and that's the publicity and the notoriety that goes along with the claim itself. And Playboy being having their name put out there in the media and the attention that these cases generate, it causes some additional concern that you've got to pay particular attention to. This recently, as we were preparing for this presentation, I just wanted to grab a recent case that got filed, and I think this one was filed yesterday or the day before here in the Michigan State Courts in Macomb County. The plaintiff, Elias Awad, who was a former executive of Chrysler, was asserting a claim against Chrysler for under the False Claims Act for alleged accounting irregularities. And his current employer, this KUKA U.S. Holdings, was terminated his employment, and now he's asserted a whistleblower claim. I believe it's under the Michigan Whistleblowers Act, an act that we'll talk about as well, but asserting a claim against his current employer or most current employer for terminating him wrongly. So as you can see, these cases get filed every day. They're usually the result of a termination where an employee has suffered some adverse action and claims that the cause of the termination was related to some protected activity. And we'll talk about the different bases of that protected activity, but essentially these whistleblower claims mostly fall in that same pattern, that there's an employee who's done something or claims that they have done something protected. The employer knew about that, and then they went ahead and had some adverse action. So those are the elements of a retaliation claim in general, and also a retaliation claim under the under various whistleblower statutes. There's protected activity, as I mentioned. There's some adverse employment action, and then the plaintiff has the burden of establishing that there is some causation or some causal relationship between the protected activity and the adverse employment action. What types of adverse employment actions are there? There's, as I mentioned, terminations are probably the biggest or the highest frequency of cases that we see in the whistleblower realm are in the termination area. But they could also be things like denials of promotion or suspension, perhaps, some kind of other written reprimand or a negative evaluation or some kind of harassment. But it could also be even something like giving somebody the cold shoulder or not including somebody in meetings anymore after they've engaged in some protected activity. Those kinds of adverse job actions could support a claim if the plaintiff could convince a judge or somebody down the road that they were mistreated or treated differently because of their protected conduct. So, protected activity, under all the various statutes that we're going to talk about in more detail, there's always a component of the first prong of the test is, did the person engage in protected activity? And that usually comes in the form of a complaint to an employer, to a state or federal agency, or to someone else. It could even be, in some cases, to the media, where they just go public with something. And most recently there was a case. It's not. We didn't really put it into the bullets or into the slideshow, but there's a case that came out of Alabama recently involving Lear Corporation and OSHA, where various employees were alleging that they were exposed to certain chemicals in the plant down there, and they were making, I believe, seats. And the OSHA investigated, but the employees also, besides going to OSHA, they went public with a YouTube video and they went to the media, and that was the judge ruled that was a protected activity, that that conduct amounted to activity that OSHA, the disclosures to OSHA as well as this would constitute a protected activity. So it doesn't have to be necessarily only a complaint to a public body. And the conduct also doesn't even really have to have been proven to violate the law. I think in the case that I was just mentioning down with Lear, I think that OSHA's initial tests of this chemical that was in the plant proved that the chemical was below the levels of harmful levels of exposure. So it wasn't even there. It turns out there really wasn't even a violation of the law. But the issue has to deal with it was the reporting of the alleged violation or the suspected belief of a violation. So keep that in mind. So let me talk briefly about some of the basic protections or the types of protected activity that would apply in whistleblower cases. Under Title VII, or the EEOC, the Equal Employment Opportunity Commission, has the responsibility for enforcement of Title VII, which prohibits discrimination, as you know, on the basis of race, age, sex, and other protected categories. The law itself also has a retaliation provision in it that says that if somebody is terminated or has an adverse action, a job action, related to an opposition to a practice that they believe to be unlawful discrimination, or they complain about discrimination against themselves or a coworker, or they threaten to file a charge of discrimination, or they participate in a witness interview with the EEOC or something to that effect, or even if they refuse to obey an order that they believe to be discriminatory, then that will be the basis of a retaliation or a whistleblower-type claim under Title VII that could give rise to a claim against your company. So that's the first basis, really, of a type of whistleblower claim that we're addressing is this claim under EEOC or Title VII. If examples might include, somebody requested reasonable accommodation based on a religion or a disability, and then they're terminated after, that type of retaliation would support a claim. Again, here are just a couple of examples, like I just mentioned. We had a case recently here in Michigan where an employee brought to HR a complaint of sexual harassment by a coworker. This was a male supervisor, production supervisor, line supervisor, brought a claim of a union hourly female forward to HR, claiming that the woman was reporting sexual harassment by another manager, and he was subsequently terminated for performance, the production supervisor, and later asserted a claim that he believed he was terminated because he brought the complaint forward to HR by the hourly female against the other manager. So that's a good example of a real-world example of somebody who, asserted a claim for retaliation and whistleblower's claim for participating in a sexual harassment case. Not all activity, according to the EEOC, is protected. There could be unlawful activities. The biggest one is probably threats of violence, or if somebody does some act of violence, obviously that's not going to be protected. But generally, if they're just voicing their opinion, if they participate in some kind of investigation, and they're acting and their conduct is lawful, then that would be protected activity. I'm going to turn it over to Felicia, and we're going to talk about some of the more automotive-related statutes and bases for whistleblower claims, and most of those are enforced by OSHA.
So we'll talk a little bit about OSHA. I think when most people think of OSHA, you think of the OSHA or the OSH Act, which is about the workplace environment, safe working conditions, but OSHA actually has taken on a larger and larger role in terms of investigating and receiving complaints about whistleblower activity under a number of statutes, not just the what you think of when you think of OSHA statutes. So there are many statutes that OSHA covers. I think it's over 20 at this point. We'll list just a few of them. Many will apply to the automotive industry as well as other industries. There's the Surface Transportation Assistance Act, the Asbestos Hazard Emergency Response Act. You'll see here there's a lot of them. We're not going to go into all of these, so don't worry. But I think what's important to note about OSHA is they're taking on a larger and larger role, and they have an emphasis now on whistleblower protection. And they are publicizing and encouraging whistleblower complaints to come to their agency so that they can look into them. They recently came out with a new investigation manual that includes a whole section on their whistleblower investigations. One of the new statutes that's been added underneath OSHA's purview is what's called MAP 21. It's the Moving Ahead for Progress in the 21st Century Act, which was a really broad, wide, sweeping act that was it started out as appropriations type bill funding for a number of federal programs that fall under the National Highway Traffic Safety Administration. So it increased enforcement. It did a number of things. One of the things that it added under this MAP 21 is a section that protects whistleblowers. And it was signed into law in 2012. And then OSHA took over responsibility of policing basically whistleblower complaints under this act. And so who it protects is it basically, the whistleblower section, it prohibits motor vehicle manufacturers, part suppliers, and dealerships from retaliating against their employees for engaging in protected activities. So as Jeff went over, those are the sort of basic components of a whistleblower claim. You have your employee, they're engaging in protected activity, there's a claim for retaliation for engaging in that activity. The difference about this statute is it is focused on these types of employers, motor vehicle manufacturers, part suppliers, dealerships. And the protected activity under this law, as Jeff mentions in various whistleblower statutes, what's protected varies a little bit statute to statute. So in this one, it's one of the protected activities is providing info, and that can be to your employer, so just an internal report to their manager, to HR, to a number of people internally, or providing information to the Department of Transportation. So these whistleblower activities, they don't necessarily just have to be something that's provided externally to a public body. It can be something that you just, you tell your manager, the manager knows about it, and then that's considered protected activity. So in addition to providing info, like many of these statutes, testifying, assisting, or participating in investigations, or like with the EEOC statutes, objecting to or refusing to participate in an activity. So it doesn't necessarily have to be that they go to HR and complain about something specific, but if someone asks an employee to do something that they believe is in violation of one of these laws, then just objecting to or refusing to participate in something they believe is a violation is considered protected activity as well. So retaliation claims under this law are filed with OSHA, as many of them are, and as many of them have, there is a limitation of the time in which they can be filed. So with MAP 21, it's 180 days after the alleged retaliation. That's a pretty typical time frame. A lot of them are about 180 days. So some of them are shorter, but that's a pretty typical time frame.
And one thing I think I also want to add before we move on from MAP 21 is that, some whistleblower statutes and authorities permit employees to have a private right of action where they can go to court on their own and file a lawsuit. MAP 21 does not have a private right of cause of action. The employee has to file a claim with the Department of Labor first, but there's what they call a kick-out provision in the MAP 21 section that says that if the department doesn't issue a final decision within a certain time period, I think in 210 days in the case of MAP 21, then the employee can then go directly to federal court and file a complaint. So there are some provisions that allow employees to actually go to court and file a claim, and so you want to keep that in mind as well. And then the only other point I would mention with respect to MAP or really any of the statutes that are enforced by OSHA, I think that the OSHA website does have a lot of resources on there that could help you if you're interested in looking at the various whistleblower statutes that are enforced by OSHA. They have certain fact sheets or little forms that could help you understand those different statutory bases that OSHA is enforcing. And then, of course, the manual that Felicia mentioned, the Whistleblower's Manual, that just came out in May of this year, and I think it was the first time in like 4 years that they updated it. But it's a pretty comprehensive statute and talks a lot about how their investigators at OSHA are tasked with investigating all of these whistleblower complaints. And it's funny because OSHA, you think safety and health because that's what names are in the agency's name, but for whatever reason they're tasked with investigating Sarbanes Oxley, even though that's has a financial basis to it. So it's just kind of they were tasked for whatever reason with the obligation or the responsibility for investigating whistleblower claims in general. So let's move on to the Consumer Product Safety Improvement Act of 2008. This was another statute that's enforced by OSHA, and it goes to ensuring that providing whistleblowers protection with respect to consumer products. So it came out obviously in 2008, and what the statute says is that an employer cannot retaliate against any employee who, again, engages in protected activity, a common theme with all of the whistleblower statutes that we're talking about. But if they provide or is about to provide to the employer, the state, or the federal government any violation, a substantive violation of the Consumer Product Safety Improvement Act, or if they testify in any proceeding or participate in any investigation or do anything that would be a potential violation of the Act, then the employee can bring a claim under this within 180 days and assert a whistleblower claim. The good thing on these whistleblower claims, as you can see, both with MAP 21, with the Consumer Product Safety Act, even with the Whistleblower Protection Act under Michigan law, the time frame for bringing these cases is pretty small. It's not a 3-year statute of limitations or even a 1-year statute of limitations in these cases. These time limits for somebody to assert a claim, it really does benefit the employer to a large extent because the time periods are very short. They're 180 days is a 6-month time period to bring a claim at most. That's a pretty short statute of limitations period. Under OSHA itself, under Section 11C of OSHA, which is the bulk of retaliation and the bulk of whistleblower claims, by the way, are under the OSHA Act. Every year, you have probably in the neighborhood of 2,500 cases getting filed with OSHA. And that's been about their average for nationwide for whistleblower claims. And of that 2,500, probably close to 1,800 of those are brought under OSHA itself, under the OSHA Act, saying, in other words, people are complaining that they were reporting conditions in their workplace that were dangerous or could lead to some kind of injury, and they report that, and then they're terminated as a result, or that they suffer some adverse consequence. And the time period to bring that kind of claim is only 30 days. So if somebody doesn't bring a claim within 30 days, they miss their window, and they're out of court basically. So with respect to a claim under OSHA 11C, it's a little longer under consumer products and also under MAP 21. But my point is that it's not a 3-year statute of limitations. So if somebody sleeps on their rights for 6 months and they don't bring a claim, then that could be a potential defense to these types of claims. I mentioned the Michigan Whistleblowers Protection Act. This is a state law that creates a private right of action, so an employee can go directly to court and bring a lawsuit. And that Whistleblower Protection Act prohibits an employer from discharging again or threatening or doing any kind of taking adverse job action because somebody is about to or actually reports a violation of a federal or state statute to a public body. So again, broad application of an act. We see a lot of times that allegations of under the Whistleblowers Protection Act are asserted in connection with a substantive violation of a different statute, like Title VII or the Michigan Elliott-Larsen Civil Rights Act. Protected activity, again, under Michigan WPA is the same as some of the other things we've mentioned. The person is going to report some violation, or they mentioned that they were going to report a violation of the law. I mentioned the 90-day statute of limitations for bringing those claims, and one of the points on the previous slide that I probably should have just emphasized, is that in order for the plaintiff to prevail, they have to prove that the employer had notice. So when we're defending these types of claims, sometimes our best defense is the lack of knowledge. So if we don't know the plaintiff or the former employee engaged in that kind of activity until after they were terminated, you can see that would be a good defense. And we've had, in the case I mentioned to you earlier, where the plaintiff claims that they brought the sexual harassment complaint to HR, one of the prime defenses was that HR said, well, we didn't even know that this person had any role in that sexual harassment complaint at all when we made the termination decision. And we have enough evidence to support that position, so I think the case will be decided favorably. Keep in mind, damages in these kinds of cases could be substantial if an employee does prove that they were terminated for engaging in this kind of conduct. You're looking at back pay, you look at reinstatement, and damages plus attorney's fees. So the cost of these cases could be substantial. Before I turn it back over to Felicia, Felicia and I were talking about whistleblower cases in general before the call, and I think they're particularly difficult to defend sometimes because when you have a regular discrimination case, for instance, somebody is, let's say, a minority who's asserting a claim of race discrimination. You can look at performance and you can say, well, no, the real reason for the termination was that the person was not performing well. And if you have documentation to back that up, generally you're going to be in a good position, at least for summary judgment, if you get the right judge. With whistleblowers' complaints, it's usually that the person isn't getting along well with people because of their reporting, or sometimes the conduct that leads to the termination is kind of wrapped up with the conduct that they claim to be protected. So it's a little bit trickier on these kinds of cases to evaluate, the performance and separate that from the protected activity. So it just causes, the decision makers to have to really analyze this a little bit and give it a little bit more close scrutiny. So, and we'll talk about that later in some of the strategies for prevention, but I thought I'd raise it now as well.
So the next statute we're going to talk about is Sarbanes-Oxley. It's a pretty well-known statute. I'm sure most of you on the phone are familiar with it. It applies to certain companies, publicly traded, and companies that are required to file certain reports with the SEC. It was enacted in 2002, and it introduced pretty major changes to the regulation of financial practice in corporations, as well as a lot of corporate governance requirements. So one of the things it includes, as all these statutes do that we were talking about, is protections for whistleblowers. from retaliation for certain reporting acts. So under Sarbanes-Oxley, it's all geared towards, reporting violations of these financial regulations. So that's mail wire bank and securities fraud, that's violations of SEC rules and regulations, or federal law relating to fraud against shareholders. So like I said, pretty financially focused. Under the Act, you can't retaliate against certain employees. Again, here's the protected activity. Providing information, and the people that they're providing information to, as we've seen, can change a little bit from statute to statute. Under Sarbanes-Oxley, federal regulatory or law enforcement agency, a member or committee of Congress. So that raises a question. As Jeff talked earlier about the employee who goes public. Well, if an employee has a concern that there's a violation of Sarbanes-Oxley and they write a letter to their congressman about it, that can potentially be protected activity because they're reporting it to a member of Congress. So it's things that you may not necessarily think of as protected activity. As Jeff mentioned, obviously you would have to know about that letter to Congress for it to be retaliation. But I just wanted to point out that, from law to law, the nuances of what's protected changes a little bit, and it's just something to keep in mind. Here again, filing a charge, participating in a proceeding about violations of SEC rules is really what the focus is of Sarbanes-Oxley. OSHA, again, controls complaints and investigates complaints, receives complaints about this. Like Jeff said, you don't usually think of OSHA as governing this type of statute, this type of claim, but they're taking on a larger and larger role. Once again, 180 days on this one, which in the big picture is pretty short. So what we wanted to do is just give you an example of a retaliation claim so you can kind of see how these types of claims play out. And, in this case, we can think about what the employer's actions are, what they may have done a little bit differently, how things went wrong. So this case is called Collins v. Beezer Homes. It is, she actually worked in Florida, but the case was filed in Georgia, 2004. She was hired into this firm as the director of marketing at their Jacksonville office. Soon after she started, started having conflict with her manager, the VP of sales, the president of the division, a number of people in her office. She didn't like the management style, and she was concerned about the way marketing expenses were being categorized. She was concerned about the way they were paying certain vendors. So she had a number of complaints, not all of which would fall under protected activity. And this goes back to what Jeff was saying about how behavior that you could potentially terminate someone for without a problem can get wrapped up in protected activity. It's hard to kind of disentangle once you have someone who has engaged in protected activity. You just have to be really careful. So what she alleged was she wanted to switch advertisers, and she tried to do so. The president of the division overruled her, said they had to keep paying the original advertising company. She thought that was because they had a personal friendship. So she alleged that there were these kickbacks going back and forth between the advertising agency and Beezer Homes. She had a concern about marketing expenses. And then she also had a concern that once she started reporting these things to people, there was this cover-up. So she talked to a number of people, the HR representative, she talked to the VP of sales, she talked to eventually the CEO and said, I'm making all these complaints, nothing's coming of it, all they're doing is covering things up, there's rampant corruption, and you know that once someone's complaining about things, they don't feel like their complaints are getting addressed, and they're writing to the CEO about cover-ups, that you're in a bad situation and you should be concerned about it. So she was not satisfied that she was getting the answers she wanted when it was pretty near the beginning of her employment. And in the beginning of her employment with Beezer Homes, they had this initial 90-day period with sort of a probationary period. In her employment agreement, they said either party could terminate the employment arrangement for no reason. And so the employer liked that provision and kind of jumped on it. 2 weeks after she started complaining about these problems that she saw, she was terminated. And the reason for her termination, she was terminated by one of the people she was complaining about, and the reason for her termination was given that she did not get along with her fellow employees. So as Jeff said, that's tangled up in all this, right? I mean, one of the reasons she wasn't getting along with her fellow employees is because she was accusing them of breaking the law. So while not getting along with your fellow employees might be a valid reason to have concerns about a new employee and terminate them in your 90-day probationary period, because what she was complaining about was financial wrongdoing, they really had to be pretty careful about how they treated her. But they terminated her. She filed a complaint with OSHA under Sarbanes-Oxley. Then OSHA also has this kick-out provision. So after about a little more than 6 months of her complaint with OSHA, she filed a lawsuit against the company, Sarbanes Oxley Claims and Florida Whistleblower Act claims. So the court did an analysis of her claims, went through the analysis that we've been talking about a lot today. Did she engage in protected activity? The court says yes. Some, not all of her complaints, but some of her complaints were about financial wrongdoing that fell under Sarbanes-Oxley. The employer was aware of it. She had reported to everybody, including the CEO. She was fired, so you have your adverse employment action. And one of the things that they look at when they're trying to determine causation is the proximity in time of the adverse employment action to the protected activity. If all this protected activity had occurred 5 years before and then she gets fired for a different reason 5 years later, that looks a lot better, obviously. But here we only had 2 weeks between her complaint and her termination. The court determined that gives the suggestion that her protected activity contributed to her termination. So the real problem was that the employer couldn't show that they would have terminated her absent all this complaining she did about financial wrongdoing, and the court held that the case could go to trial. So as Jeff mentioned, a lot of negative exposure, a lot of upheaval, a lot of money out the door even to this point, and then they had to go on to a trial, risk the jury award and the additional legal fees of getting that far. So I think, as you can imagine, there were a lot of things, a lot of steps along the way where the employer made decisions about how to handle things that maybe weren't the best decision and sort of kept this along the path towards litigation, where if they had taken her complaints seriously, investigated them properly, taken the people she was complaining about out of the decision to terminate her. We'll talk about all the strategies and the tools that you'll have to combat this kind of claim, but you can see how the employer's behavior in this case really contributed to the outcome, which was this extensive litigation. So now we're just going to talk about one statute that is in the works in Congress that applies specifically to the automotive industry. It is called the Motor Vehicle Safety Whistleblower Act. And what it is, and there are other statutes that provide this as well, but this one's new specifically for motor vehicle safety issues. It's like an incentive statute. So what it is to encourage whistleblower claims. It provides whistleblowers incentives and some protections. Again, it's for the same employees that we looked at under MAP 21, employees of motor vehicle manufacturers, part suppliers, dealerships, and their contractors. If they voluntarily provide information to the Department of Transportation relating to a defect or some kind of noncompliance or violation of these laws and regulations and product safety rules regarding motor vehicles, they can get a piece of the action, basically. So if the government gets monetary sanctions, gets administrative or judicial action, so that's a court case, that's penalties, fines, even a settlement, if your information or the whistleblower's information leads to a settlement or a receiving of more than $1 million into the Department of Transportation, then the whistleblower can get up to 30% of that reward. If there's more than one whistleblower, they obviously split that up. But what it is an incentive for whistleblowers to come forward with credible information, and if it ends up leading to these monetary sanctions, they can get a portion of it. The protections it offers, these whistleblowers already have their MAP 21 protection, so if they're protected from retaliation under that statute, this new act, if it passes, would just protect their confidentiality. So it says if they provide this information to the Department of Transportation, they won't release who the whistleblower is until they get to the point in the case where they have to, by law, release that person's information. So that has passed the Senate. It is now under consideration at the House of Representatives, and we will see if that becomes law. As I mentioned, there are other statutes that have these types of incentives. So if this could be coming down the road in the automotive industry.
This is like Crime Stoppers of the industry. So we're going to move on just to kind of, before we get into questions and answers, talk about some strategies and to avoid whistleblower claims. I think that's what you're all really interested in hearing. And I think it starts with policies and procedures. You have to, first off, have clear anti-retaliation policies in your policy manuals and handbooks, ethics policies and whatnot that are well publicized to employees and that they understand that these are the policies with respect to anti-retaliation. And not just the employees who are doing the complaining, but it's really the manager level folks who understand the significance and the liability related to retaliation, that they have to be informed that they can't retaliate against people and just understand the policies. There has to be an internal reporting procedure for whistleblower claims, so that if people understand that if they believe there's wrongdoing of any kind, there has to be a climate and a procedure for people to go and report those whistleblower claims, just as they would discrimination, if there was product issues or financial irregularities. All of those kinds of things lend themselves to reporting, and the first way to avoid a whistleblower claim by somebody going to the government and reporting something is if they feel that they can report something internally without being retaliated against and perhaps result in some change. And again, as I mentioned, the last bullet is create a culture that supports reporting. All that's pretty easy. Training and retraining employees and HR on the substantive basis of the retaliation statutes that we talked about, I think is helpful, at least so that they have an understanding that they could be potentially personally at risk. In some of these statutes provide for personal liability for somebody who engages in retaliation under whistleblower statutes, but also just that they're just trained generally to understand that this is the right way to report, and the way that, so that they understand how it works at your company. You train employees regarding reporting procedures, like I said, the anti-retaliation policy. You train all personnel that are involved in receiving the reports and conducting investigations. HR, again, they bear a lot of responsibility here because they're charged with investigations usually in their companies and making sure that they remain unbiased. They do a complete investigation into complaints. But oftentimes, this is the situation where somebody reports something and then there's an investigation. And then obviously you'd want to do a prompt and complete investigation. If there was some remedial action, some fix to change a wrongful conduct or some kind of unsafe situation, that would be appropriate. And then following up with the employee at the end of the investigation, just like you would with most investigations, and to kind of tell the employee what came of that. I think with whistleblower claims, more often than not, the company terminates somebody because they believe that they were doing something wrong, or that they weren't cutting it, or whatever the basis for the termination is. Could even be just a reduction in force, potentially. So the employer doesn't really think about potential whistleblower claims when it makes a termination decision. So oftentimes there's not a way to investigate beforehand. All of that comes in after the fact. That's why this last slide is important. So document. I think not only do you have to document the investigation that you do, but I think just in terms of termination decisions and adverse employment action decisions, those all have to be clearly documented. And I know, documentation is it's a problem across the board. A lot of times our clients, I'll hear that they want to fire somebody because they just want to go in a different direction. The person's just not cutting it. And then I ask the follow-up questions, okay, like, well, what documents, or what are there emails that show that the person's not doing well? Are there documents that support that? No, we didn't really document it well. And that's a problem, because then, it's easy for the plaintiff to come back later and say, well, the real reason was that I complained about these kickbacks that this supplier was getting, or that the real reason was something, that I had gone to the EEOC and complained. And unless you have a real good documented performance chain, that's going to be a problem for the company. But there's a couple of things I want you to think about and take away, when it comes to decisions with respect to terminations. And I'll kind of rope this back into the Lear case that we mentioned previously. I think the first thing that you need to decide when you're making termination decisions, for each and every person that you terminate, there has to be an analysis, and that analysis has to start with saying, does the termination of this employee support our company's mission and values? And you have to consider that for every person, specifically, because even one person being terminated, if that person goes on YouTube, if they go on Facebook, if they go to Channel 2 News Problem Solvers, and they make an issue of their termination, that's going to be adverse publicity that you probably don't need. And you have to look at the decision in the context of the evidence and the facts that you have to make that decision. And as long as you feel comfortable that that decision is based on a legitimate, non-discriminatory reason and not retaliation for conduct that could be viewed as protected, then I think you're going to be okay. The other point I would ask you to think about is, how does the decision look in hindsight? If when a judge or a jury is looking at this down the road, this termination, is it the situation with the Beezer Homes case that we talked about, where the person was terminated 14 days after they start making noise about some wrongful conduct? Or is there a pattern of conduct where the person's performing poorly, that you sit down with them, you explain to them what their deficiencies are, you give them an opportunity to correct those deficiencies, and then they screw up again, or they don't make the changes that you are advising them to make? So then that's a different scenario. So, would you rather be in the first situation where somebody just makes noise and fired 14 days later without a real good documented performance chain, or the second situation? And I submit to you that, the only one that's going to make sense in hindsight is the one that is well documented and well reasoned, and it looks fair to the employee. It looks fair to a judge or a jury down the road, and they're going to be in a situation looking at it, completely as a stranger to the situation. They're going to say, well, does this make sense? Is it consistent with how you treated other employees for the same kind of conduct? Or, is there something, is it as a result of some illegal retaliation? So, do you have anything, Felicia, to add to that?
Nope.
Okay, so we're going to move on and address one of the questions. I don't see it coming up, but I thought there may have been a question, maybe not. Why don't we move on then to the next slide, which is our poll question slide. And what I will do is read off the code, and we are given the code 30, 3 O as in Oscar, Kilo K as in Kilo, 3 7. I'll read that again. It's 3 O K 3 7. That's our code today for CLE, 3 OK 3 7. And if there's any questions with that, feel free to let me know. I think we've addressed all the substantive parts of the slides that we wanted to hit. We can make the slides available to you if you or email them to you. All you have to do is just shoot me an email at jkopp@foley.com, or Felicia O'Connor, F. O'Connor.
It's FOCONNOR.
at Foley.com. and we'd be happy to answer any questions offline or provide you any materials with respect to these statutes or the slides themselves. I believe the phone line is not open for questions, so if you do have any questions, it would be best for you to type those into the Q&A box on your screen, and we'll be happy to take them right now. I don't see that there are any at this point, so we'll give you guys maybe a minute to decide if you want to ask any questions. If not, then we'll just end just a bit early. I think we're about 8 minutes ahead of schedule, but I think we've satisfied the CLE requirement. So again, it's our pleasure to talk to you about this topic today. It is a pretty important topic, so hopefully we fulfilled our mission of trying to educate you about some of these whistleblower statutes, especially in the automotive industry with that particular focus, and also to give you some kind of strategies in terms of moving forward. I mean, obviously the best strategy is documenting what you're doing and really kind of looking at these situations with patience, and looking at it, looking at how terminations are going to play out to a jury down the road, especially if you know that somebody has engaged in some kind of protected activity before the termination. So with that, we're not seeing any additional questions, and I don't want to keep belaboring the point. So thank you again, everyone, for your time and your attention here today. Have a great day.